And did she indicate whether it was a male voice, a female voice, loud, soft?
She alluded to the fact that it was a male voice and it was persistent. Lindsay talks frequently about her children. She loves them deeply. She carries immense grief.
And you also said that this voice, talking about the voice, came up in several of your meetings, correct?
Correct.
And you never once wrote about any of it in any of your very detailed notes, correct?
Day 17 of the Lindsay Clancy trial opened quietly and ended with two fights that could shape the entire verdict. A hospital chaplain took the stand and described a mother who, days after her 3 children died, spoke of a male voice that had warned her nothing would be safe unless she obeyed it. Hours later, in a hearing the jury never saw, both sides argued over which legal doors the jury will even be allowed to walk through when they finally deliberate. Before any of that, the day started the way most trial days do, with the judge making sure 12 ordinary people were still able to do an extraordinary job.
This court is now in session. You may be seated.
Yes, please.
For today, we have the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague.
None of this is dramatic. That's the point. Every trial day starts with the judge protecting the record, making sure nothing has reached the jury from outside the courtroom, and making sure a scheduling hiccup doesn't get read as a signal about either side's case. It's also a reminder that this jury has been sitting through this for weeks, and today they were told to expect an easier morning. What followed was anything but easy to listen to.
All right. Thank you, Madam Clerk. Good morning, everyone. Nice to see you again. I know I just spoke to you probably about 10 minutes ago. But again, I want to ask you those questions, then we'll talk a little bit about what our schedule is today and for the rest of the week. All right, so first question, has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be fair and impartial as a juror? Next, is there any other serious matter or concern bearing on your service as a juror that anybody needs to bring to my attention at this time? Again, thank you for following those instructions. And then in regards to our schedule today, you're allowed to kind of roll your eyes because I'm going to say we're going to have kind of a short day today. All right? And that is, as I talked to you yesterday about an issue that has nothing to do with any of the attorneys in this case. All right? It's just something we're going to work out, and I anticipate it will be worked out so that tomorrow you should count on a lengthier day. All right?
Cavanaugh wasn't called as a psychiatrist, a forensic examiner, or an investigator. She met Lindsay as a chaplain, spiritual care, comfort, confidential conversation. She could describe what she saw and what she remembers hearing, but she wasn't offering a clinical opinion. Because Lindsay couldn't speak during those first visits, the conversation that matters most came later, after the breathing tube was removed.
Thank you. Good morning. Can you tell us your name and spell your last name, please?
My name is Sheila Cavanaugh, C-A-V-A-N-A-U-G-H.
And what town do you live in?
I live in the town of Belmont, Massachusetts.
And what are you doing for work now?
I am a board-certified chaplain at Brigham and Women's Hospital in Boston.
In the course of your duties as a chaplain at Brigham and Women's Hospital, did circumstances bring you in contact with Lindsay Clancy?
Yes, they did.
Can you tell the jurors what happened?
I arrived on the morning of Wednesday, January 25th, 2023. I arrived at approximately 8:30 that morning because I was there to relieve the overnight chaplain who was carrying the pager. I was taking over the pager shift, which went from 9 to 1 p.m., although I was working a full day. When I arrived that morning, she said to me, "Did you hear the news?" And
Sustain.
Okay.
So you can't, I don't object, so you can't say what someone told you, okay? That's called hearsay?
okay.
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 So I can say, as a result of the conversation with that person, what happened?
I was summoned to the director of spiritual care's office.
Did you have a conversation with her?
I did.
All right. And as a result of that conversation, what did you do?
I went to Unit 8C in the Tower building of Brigham to meet with Lindsay Clancy.
And what time of day was this?
Roughly between 8:30 and 9:30 that morning.
And when you went in to see Lindsay, what did you observe?
Well, the unit itself was filled with law enforcement officers, both outside the doors of the unit. There was Brigham security, but the unit itself was flooded. There were people from Plymouth County, Boston City Police, Brigham Security, so I had to make my way through concentric circles of law enforcement to even get to the room. I was permitted to see Lindsay, although she could not speak at that time.
And what was her condition that you observed?
She was dressed in medical armor. She had tubes, she was intubated, she had bandages, she had a neck brace. She was just covered and layered in equipment that enabled her to breathe.
Now, I'm showing you Exhibit 121 and asking, this may be South Shore, or it could be Brigham and Women's, but is this indicative of what she appeared to be when you first saw her?
That looks like it's from South Shore because when,
Shore?
yes.
Did she have the same?
Similar.
Very similar?
Very similar.
Like that?
Yes.
That's a direct account, from a witness who says she was in the room, of Lindsay describing a voice within days of the killings. It's also, standing alone, incomplete. It doesn't establish when the voice began, whether it preceded the children's deaths, or whether it affected Lindsay's ability to understand or control her actions at the moment that mattered. Cavanaugh described a relationship that continued for years afterward. That's why the testimony carries weight. But weight and reliability are two different questions, and the next 20 minutes of the hearing were entirely about the second one.
Did you see her again on another date?
I did. I saw her the next day. Again, she could not speak. She was intubated as well. That was the first week that she was hospitalized.
When was the next time that you saw her?
The next time I saw her was the following week. I have a calendar here of my visits. I saw her on Tuesday, January 31st, and she had been extubated at that point so she could speak.
So the tube had been removed, she was able to communicate, and that was on January 31st?
I believe she was extubated the weekend of the 28th, but I didn't work that weekend, so I saw her on Tuesday the 31st.
All right. Tell the jurors what you observed and what, if any, conversation you had with Lindsay on the 31st. And let me ask you, how long had it been that they removed the tube?
Perhaps a day or two.
A day or two, okay. Tell the jurors what she said to you.
She continued to look like the photograph you just saw. She was covered, tubes everywhere, the neck brace. Her emotional state was very neutral, a flat affect. But I remember vividly the first thing she said to me. Now, she had heard me for a couple of days. We had been praying together. And so when I went in on Tuesday the 31st, she said to me as I held her hand to comfort her, "I am so glad my children are safe."
Was there any other conversation that you had with her?
I replied theologically to Lindsay, and I said, "Lindsay, your children are safe. They're safe in heaven with God." And I held her hand throughout that conversation, and we prayed for them.
Did she make any other statements to you?
She did. She alluded to having heard a voice, and the voice, according to Lindsay, told her that if she did not follow the command, neither she nor her children would be safe.
And did she indicate whether it was a male voice, a female voice, loud, soft?
She alluded to the fact that it was a male voice and it was persistent.
Any further conversation that you recall about that, not about general things, you know?
That came up several times. I visited Lindsay minimally 14 times while she was hospitalized at the Brigham, and the voice conversation came up several times during several of our visits.
Now, after Lindsay was transferred or cleared to go from Brigham and Women's Hospital, did she go to another facility?
She did. She went to Spalding Rehabilitation Hospital.
The prosecutor moved from sympathy to the record. She established that Cavanaugh had written detailed notes after essentially every visit, dozens of them, over more than 3 years. Then came the question that reframed everything. If the male voice came up more than once, where is it in those notes?
So did she express anything about her children and their loss over that period of 200 times that you saw her thereabouts in Tewksbury?
Objection.
No, overruled.
Yes.
Other jurors?
Lindsay talks frequently about her children. She loves them deeply. She carries immense grief.
Objection.
Overruled. Next question.
And has that continued to your observation?
It continues presently.
When was the last time that you saw Lindsay in Tewksbury?
Just prior to the trial starting.
The chaplain's notes preserve plenty, including direct quotations. They don't preserve the one detail now central to the defense's theory of the case. There are several ways to read that gap. A confidential spiritual exchange may have been left out on purpose. The memory may have sharpened over time, or the notes may simply never have been meant to capture everything. The missing entry doesn't resolve which explanation is right. It just gives the jury something concrete to weigh, instead of judging the claim on the witness's confidence alone.
Perhaps.
Now, you mentioned that on January 31st, 2023, you spoke to the defendant, and she told you that she heard a voice telling her that if she did not follow the command, neither she nor her children would be safe, correct?
Correct.
You wrote very detailed notes that are contained in the Brigham and Women's Hospital records regarding your interactions with Lindsay Clancy, didn't you?
Yes, I did.
And in all of these notes that detail every time you interacted with her, you never once wrote that she told you she heard a voice or what that voice said, correct?
Correct.
And you also said that this voice, talking about the voice, came up in several of your meetings, correct?
Correct.
And you never once wrote about any of it in any of your very detailed notes, correct?
Well, chaplain notes are not verbatim transcripts of patient conversations. I'm not there to evaluate the patient. I'm there to bear witness to their suffering.
Okay, but the question was, you did not document those statements in your notes, correct?
Correct.
But you did document some other statements in those notes, correct?
Perhaps.
For example, on February 6th, 2023, in a note that you wrote regarding your interaction with the defendant, you said that, or you wrote, Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again, end quote. She continued to express her fears of how her inability to walk may make her vulnerable to others in the future. Do you recall writing that?
Yes.
Do you recall writing on February 9th, 2023, that the defendant was sitting in a chair adjacent to her bed and appeared to be visibly engaged, energized, and hopeful than in previous visits? Do you recall that?
Yes.
You also wrote in that note, Lindsay spoke hopefully of being discharged when the time arrives to Spalding, correct?
Correct.
And then in February 13th, 2023, you wrote in your note that Lindsay also expressed hopefulness in relation to her physical progress. She feels she has gained considerable physical strength and agility despite an inability to move her legs. She admitted that she feels, quote, deserving of this, end quote, in light of recent events. Do you remember writing that?
Yes.
Do you remember on February 16th, 2023, that you wrote in a note that the defendant expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted that she would be cared for in a facility with an excellent reputation?
Yes.
Do you recall writing on February 16th, 2023, that Paula, the defendant's mother, and Lindsay, the defendant, were playing a card game as they communed quietly, and that Lindsay expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted?
Yes.
And again, you've got all these details about her feelings and her thoughts and what she's doing, but nothing about the voices that you spoke of so many times, correct?
Correct.
And
Neither side erased the other's point. The defense gave the jury a reason the omission might be innocent. The prosecution showed the witness clearly could and did record direct quotes when she thought they belonged in the file, which makes the one glaring absence harder to wave away. That argument was still unresolved when the jury went home for the day. What happened next, they never saw at all.
Because I'm not a medically trained clinician, I approach patients in a vortex of trust. Some of our chaplains at the Brigham are ordained clergy. And so there's this understanding that when a patient interacts with a chaplain, the conversations are confidential.
Do you put them in medical records?
No.
The words, like Lindsay indicated that she felt uplifted, I think the counsel read that twice. Were those your notes, or is that what she said to you? Did she say, "I feel uplifted," or is that your
was my
observation?
perception of Lindsay. It was not her words.
Thank you.
Thank you.
Como?
you said you're not allowed to put the defendant's words in your medical records, is that correct?
No, that's not correct. It's not that I'm not allowed. It's an understanding, and it's a conversation that's held in confidence with the patient.
Then why are there direct quotes in these medical records from the defendant?
Well, they're not verbatim transcripts.
No, not a transcript of the whole conversation, but you put phrases in quotes. For example, on February 6, 2023, where it says Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again. So those were her words in your note, in quotes, in the medical record, correct?
Yes,
Thank
yes.
you.
I use my best judgment.
Okay. I would move to have these submitted as the next exhibit, the notes of the witness in her interactions with Ms. Clancy at the Brigham and Women.
Any objection?
No.
All right. They may be admitted.
This is bigger than the chaplain's testimony. If the judge leaves intoxication out of the instructions entirely, the jury never gets to consider it, no matter what the medical experts say later in the trial. The Commonwealth wants the analysis locked onto one date, January 24th, 2023, and nothing before it.
In terms of the criminal responsibility instruction, we're asking that the instruction regarding intoxication not be given because from our perspective, there's been no evidence of intoxication by drugs and or alcohol during the killings. There's testimony, and I think there'll be more testimony about the defendant taking pills after killing the children, and before killing the children, she was on low-dose prescription 10 milligrams of amitriptyline that was recently increased to 20 milligrams, but there's no real evidence of whether or not she actually increased that dose. And then it was a low dose of trazodone and a low dose of, I believe, Valium. So those were prescribed medications that she had reported no side effects from, and I believe in the text with her mother, she said that she was still waiting to actually feel effects from those. So there's no evidence of intoxication from those drugs. And then the only intoxication potentially could be when she took pills after killing the children. And even those amounts from the toxicology are low-level amounts. So we're asking that the instruction on intoxication not be given.
I don't know if the government has been listening to the same evidence in this case. This is clearly an involuntary intoxication defense, at least as far as the judge's charge. to the jury based upon the evidence that's been presented, whether or not it's what we would argue is the over-prescription of the medications, whether or not it's the side effects of the medications, whether or not it's the titration or the termination or the immediate cessation of the medications against what normal medical advice would be. All of those factors contribute to the state of mind of Ms. Clancy that was expressed to a lot of people, family members, people that knew her. She had indicated, I think Your Honor knows the evidence repeatedly indicated that she was affected by the benzos. She was felt that she was being addicted to the benzos, trying to get off the benzos. She indicated that the sertraline was obviously killing her as far as going from 25 to 50 milligrams, and then subsequent to that when there's additional SSRIs prescribed. To suggest that there's no basis to give the jury the instruction, they may determine based on the evidence that is as a result of the involuntary intoxication from narcotics, not alcohol, obviously, from the prescribed narcotics, not illegal drugs. So from the prescription drugs, that's on all fours with a valid defense that they should be instructed as it relates to involuntary intoxication. I think it's the model jury instructions on criminal responsibility. Obviously, if there's any nuances that I would pick up, I would bring that to the court's attention. But I have tried murder case recently with the model jury instructions, and my memory is that I was pretty satisfied. It was Judge O'Shea, I think, actually in this courtroom a year ago, and I was satisfied with the instructions on lack of criminal responsibility. I would, at some point, ask the court to charge on involuntary manslaughter. I'd ask the court to charge on wanton conduct with a component of the impact of the intoxication. So you can't try this case in a vacuum. You can't present the case to the jury. I know the government would like to present the case only on cruelty and atrocity. They probably don't like the statute that allows a jury to determine the degree of murder, which would be first and second, but I think that the evidence is such that a jury should have the option of considering whether or not we're talking about involuntary manslaughter based upon the evidence that's permitted. So I would defer to the court on the instructions on cruelty and atrocity, premeditated malice aforethought, second degree malice. I would ask the court to consider instructing on involuntary intoxication, to consider on the involuntary manslaughter as a lesser offense, and anything else that I can think of. But right now, that's what I can think of.
Thank you. Commonwealth did request first and second degree instructions. It's our position that involuntary manslaughter wouldn't apply here. The evidence is that there was a specific intent to cause the death. So there's nothing that I can think of in the involuntary instruction that would apply here. Going back to the intoxication just for a moment.
Sure.
All of the medications, most of the medications that defense counsel talked about that the defendant was having reactions to and side effects from were before her hospitalization at McLean Hospital, and she was weaned off of that last one, the Seroquel, that while she was in McLean Hospital, and then she was without those medications and they're out of her system for 3 weeks, and she's just on those other 3 medications. So the intoxication that matters is not what happened in the fall and before McLean, it's what happened on the day of the incident. It's similar if it's an OUI, it doesn't matter if you were drunk in November, it matters if you're drunk on the date of the incident. So what matters here is that January 24th, 2023, and those other drugs and the effects that they caused to her aren't relevant to what happened on that day, as they've been out of her system for at least 3 weeks at that point.
All right, so the Commonwealth's position would be that the relevant analysis is what she was taking on or around that January 24th?
Yes.
Okay.
The fight has quietly expanded. It's no longer only, was Lindsay psychotic? It's now also, does the jury even get the option of a lesser offense at all? No ruling came down in this hearing, but the instructions the judge eventually approves will decide which verdicts are on the table before deliberations even begin.
Supposed to be consideration of a chalk for the court to write out the elements of the offense of first-degree murder, cruelty and atrocity, premeditated malice of forethought, etc. And I would ask that you not do that. I don't think that it's appropriate. I think it highlights, if you will, in simplistic terms, premeditated malice of forethought. I think you and I, we just had a murder case last year on another matter, and I mean, I heard your instructions. You're very forceful with the elements of the offense, and I just don't think we need to have this appendix or whatever you want to call it. And again, I did object to that with the Judge O'Shea. We did not submit the instruction list, cookbook, or whatever you want to call it, to the jury. So I think that the court's instructions would be sufficient. I would not want to have that chalk that is referenced in the...
It's a minor exchange next to the intoxication argument, but it's not nothing. How instructions are presented, a plain reading versus a simplified checklist, can shape how a jury applies them to the facts. The defense wanted the law read to the jury, not handed to them in shorthand.
Do you think, logistically, Your Honor, that with the presentation of Dr. Resnick and then the government having their 3 doctors, hopefully we finish the evidence tomorrow, we would be closing Monday?
I would expect either Monday or Tuesday. If the parties may need, we can talk about that. But, my old experience, there's been a lot of evidence and there's a lot of witnesses. And so if the parties feel that they need like a day to kind of marshal their thoughts, we could talk about that. So either probably Monday or Tuesday. We could talk about that tomorrow. All right. Anything else we need to address, you think?
No, Your Honor.
All right. And so tomorrow we'll be in recess until tomorrow at 9 o'clock. Hopefully we'll start with Dr. Resnick and then, correct?
Yes.
Yeah, all right. You just kind of looked, I thought, oh. So that would be the thought, and then we'll just kind of go from there. If the defendant rests, the Commonwealth can then present their witnesses, and if it's not done by Friday, we go into Monday, and that may mean closings and charge on Tuesday.
Okay.
All right.
Day 17 didn't decide whether Lindsay Clancy is criminally responsible for her children's deaths. It sharpened exactly what the jury will eventually have to weigh: a vivid memory from the witness stand against a written record that stayed silent on the one detail that matters most, and a legal argument happening entirely outside the jury's view over which verdicts they'll even be allowed to consider. The most important evidence from today might not be anything said in front of the jury at all. It might be the fight over what they're going to be told once the evidence is finally over. What do you think? Does patient confidentiality explain why the voice never made it into the notes? Or should something this significant have shown up somewhere in 3 years of records? Leave your take in the comments and keep it focused on the evidence. This case involves real people and real loss. Subscribe and turn on notifications if you want the next day broken down with the same care.